A stunning courtroom moment just changed everything. A former president now faces possible criminal charges after what legal experts are calling an extraordinary confrontation with a federal judge. Reports suggest this goes beyond political drama. Court documents indicate behavior that may have crossed serious legal lines. Make sure to subscribe because developments like this are happening fast, and you'll want to stay informed. So, what exactly happened? Sources indicate that during a court hearing on January 15th, there was a dramatic exchange involving repeated refusal to follow court orders. Legal observers describe the scene as highly unusual. When judges begin using terms like willful defiance in their official statements, analysts say something significant has occurred. This situation reportedly involves financial documents that were ordered to be turned over multiple times. According to court filings, these records were requested on 3 separate occasions over several months. When the documents still had not been provided, the judge allegedly demanded direct answers. That's when things became heated. If this interests you, hit that like button to help others find this information. Here's what makes this serious. Legal sources suggest that instead of answering through attorneys as court protocol requires, there was direct speech toward the judge. Multiple witnesses who were present report that voices were raised, and the judge had to interrupt several times. One person reportedly stood up, despite their lawyers advising against it. According to the court transcript, the judge responded firmly, stating that proper courtroom procedure must be followed. But the situation continued to escalate. Reports indicate there were comments made about the fairness of the proceedings themselves, which legal experts say judges view as challenges to their authority. Court observers say what happened next was remarkable. Around 10:15 that morning, the judge called for a brief break. Sources familiar with the matter told reporters that during this recess, there were intense discussions between the defendant and legal counsel in a private room. Security staff reportedly heard raised voices. When everyone returned to the courtroom, the lead attorney allegedly tried to apologize and asked for more time to locate the documents. The judge denied this request. What followed, according to veteran court reporters, was one of the most intense judicial moments they had witnessed in decades of covering legal proceedings. The judge then made a formal statement. According to transcripts, the judge explained that after multiple orders to produce evidence, after clear warnings about what could happen if those orders were ignored, and after the behavior displayed that day, there appeared to be willful contempt of court. Drop a comment below with your reaction. I read all of them. Now here's where this becomes even more serious. The judge announced a criminal contempt referral. Court reporters say the room went completely silent. Witnesses describe a sudden change in atmosphere. The defense attorney immediately tried to object, but sources say the judge cut him off, stating that every opportunity for compliance had been given. Then came the most significant moment. The judge read specific legal language into the official record, referring the matter to federal prosecutors for potential criminal charges under laws dealing with contempt of court and possible obstruction of justice. According to the statement, the evidence showed a pattern of deliberately ignoring lawful court orders that could not be handled through regular civil penalties alone. Legal analysts explain that when a judge uses that kind of language suggesting civil penalties are not enough, it indicates the judge believes the conduct was so problematic that only criminal prosecution might address it properly. It's worth noting that the judge who made this referral was appointed by a Republican president decades ago and has a long record of nonpartisan rulings. This detail becomes important when some claim the justice system is being used for political purposes. History shows us that presidents facing legal trouble over court orders is not entirely new. Decades ago, President Nixon faced massive public backlash after trying to stop certain evidence from being released. While he wasn't held in contempt, the outcry was so strong that many historians believe it pushed him toward resignation. The pattern was similar. Resisting legal requirements led to serious consequences. President Clinton also faced contempt issues in the late 1990s. A judge held him in civil contempt for testimony issues and imposed a fine of over $90,000. However, that was civil contempt, not criminal. The difference matters greatly. Civil contempt typically results in fines. Criminal contempt can potentially result in jail time. Subscribe right now if you haven't already. This type of analysis is crucial for understanding what's really happening. Looking at past behavior provides context. In another case last year involving financial fraud allegations, a different judge reportedly fined the defendant $5,000 for violating a gag order, then raised it $10,000 per violation when the behavior continued. Legal experts point to this as evidence of a pattern where court orders are not always treated as mandatory requirements. After years of similar situations across multiple courts, sources say this federal judge decided enough was enough. So what specifically led to this unprecedented referral? Legal experts who reviewed public court documents identify several key factors. First, the repeated failure to produce requested documents after 3 direct orders reportedly established a clear pattern. Second, the courtroom outburst and speaking directly to the judge despite legal counsel's advice allegedly demonstrated what the judge called fundamental disrespect for court authority. Third, and perhaps most damaging, prosecutors reportedly revealed that some documents that were claimed not to exist were later found on company servers by a court-appointed expert. Legal analysts say this suggests the issue wasn't just failure to comply, but possibly deliberate concealment combined with false statements to the court. Here's the critical detail. Sources indicate the documents that were discovered contained internal valuations of properties that allegedly contradicted sworn statements made in previous legal proceedings. According to filings made public the next day, the internal valuations for one property alone reportedly differed from public statements by over $400 million. Legal experts explain that when someone claims documents don't exist, and then those documents are found and they allegedly prove false statements were made, the criminal exposure increases dramatically. Stay with me because the implications of this are enormous. Here's what should concern everyone, regardless of political views. If anyone, including a former president, can repeatedly ignore court orders, attack judges publicly, and face no real consequences, then the entire foundation of judicial authority begins to break down. The implications go far beyond one individual. Every future defendant in every courtroom across America could point to this case and ask why they should comply when someone else didn't have to. Once that precedent exists, legal scholars warn there's no easy way to reverse it. This situation creates a difficult challenge for political leaders. On one side, there's pressure from supporters who view any legal action as unfair persecution and demand loyalty, regardless of what evidence shows. That means defending behavior that legal students learn as contempt, criticizing the judge despite his credentials, and claiming the justice system itself is corrupt. If a former president can defy court orders, conceal documents, attack judges publicly, and face no consequences, that principle becomes meaningless. The courts become advisory bodies whose rulings apply only to those without the power to resist them. This scenario is reportedly causing significant concern within political party leadership. Reports indicate that senior party officials held an emergency conference call the morning after the contempt referral became public. According to sources familiar with the discussion, some argued for aggressive defense, framing the referral as another example of unfair targeting of their likely nominee. Others expressed deep concern that defending open defiance of court orders would push away moderate voters and suburban women who had already become less supportive of the party. The discussion reportedly grew heated with no agreement reached on how to respond publicly. Meanwhile, core supporters are rallying in predictable fashion. Social media is filled with attacks on the judge, claims that documents in question were planted, and statements that the entire judicial system has been corrupted. Fundraising messages sent within hours of the referral reportedly raised over $2 million, using language like, "They're trying to jail me for fighting for you." Things escalated further when the defendant responded on social media late that night, just hours after the contempt referral. He called the judge a radical activist despite the judge's appointment by a Republican president, claimed the referral was coordinated with the current administration to interfere in the election. and described the missing documents as complete fabrication by corrupt prosecutors. He concluded with what legal experts immediately noted as potentially problematic, stating the judge will learn that he can't push around a future president and there will be consequences. Stay with me because what comes next will change how you see this entire situation. Here's what makes that response even more remarkable. Instead of expressing any regret, any willingness to comply going forward, any recognition that defying court orders has consequences, the response doubled down with what many read as a threat against a sitting federal judge. Legal experts immediately noted that such statements could be used as evidence of continuing contempt, a factor that would matter greatly in any prosecution decision. When your defense to a contempt charge is to attack the judge and promise consequences, legal analysts say you've essentially confirmed the court's characterization of your attitude toward judicial authority. A former FBI general counsel and federal prosecutor posted that this response was perfect evidence for prosecutors in proving the willful nature of contempt. He noted that defendants who want to avoid criminal contempt typically express regret and commit to future compliance. This response did the opposite. This situation goes far beyond a single contempt referral or a single federal judge. It's about whether the judicial system has any meaningful authority over those with political power. If there are no consequences for this behavior, every defendant in America will have grounds to argue for equal treatment. How can a judge hold anyone in contempt when a former president faced the same conduct and faced no consequences? The precedent would be damaging for the administration of justice at every level. If no consequences follow, it sends a message that courts are symbolic institutions whose rulings can be ignored by anyone willing to accept the political cost of defiance. It's not just about this case. It's about whether judicial authority itself has any meaning when confronted with sufficient political power. If this information is valuable to you, hit that like button right now. Here's where we stand. A federal judge has formally referred a former president for criminal prosecution based on repeated defiance of court orders, concealment of requested documents, and courtroom conduct the judge described as deliberate disrespect for judicial authority. Legal experts across the political spectrum are acknowledging that the referral is well documented and difficult to dismiss on technical grounds. Meanwhile, the response has been to attack the judge, claim conspiracy, and issue what many interpret as a threat of retaliation. When a Republican-appointed judge with 3 decades on the bench makes a criminal referral against a former president, we've entered genuinely unprecedented territory. If there are no consequences, it sets a precedent that will echo through our legal system for generations. Future presidents will understand that court orders are optional suggestions. Future defendants will demand the same treatment. The rule of law will apply only to those without the power to resist it. Watch this story closely. Federal prosecutors have up to 90 days to convene a grand jury and decide on prosecution. The judge has scheduled another hearing for February 8th to address any remaining issues. The legal team is reportedly considering an emergency appeal to a higher court, though legal experts say the grounds for overturning a contempt referral are extremely narrow. Americans across the country are watching closely to see whether the courts can enforce their authority against the most powerful defendant they've ever faced. Before we finish, make sure to hit that subscribe button so you never miss updates like this. Here's the current situation. A former president has been referred for criminal prosecution by a federal judge for willful contempt of court. The response was to attack the judge and promise consequences. Supporters are rallying to defend him. Opponents say this proves what they've always believed about attitudes toward the rule of law, and prosecutors now face a decision that could define how history remembers this moment. This isn't just another news story that will disappear in a few days. This is a test of judicial authority happening in real time. What happens next could determine whether court orders mean anything when directed at those with political power, whether the rule of law is a genuine principle or merely a convenience, whether the judicial branch can fulfill its constitutional function as a check on power. The evidence is in the court record. The referral has been made. Now we wait to see if accountability still carries any weight in our system. The stakes have never been higher. The evidence has never been more clearly documented, and the constitutional crisis has never been more immediate. This is a moment that will be studied for generations, regardless of how it ends.